My name is Elizabeth Barravecchia. I am a partner with the Bakersfield office of Hannah Brophy. Discovery is the process at which parties, which would be the injured worker and the defendant, which could be the employer who's self-insured or the insurance carrier. And it's the process at which they gather evidence in order to determine what benefits the injured worker is due. Well, there's different types of discovery. Okay, discovery can be medical evidence, which could be treating doctor reports that the injured worker is treating for the work-related injury. It could also be medical records from their private doctor. A lot of injured workers have pre-existing conditions that might be playing a role in their current workers' compensation injury. It also can be subpoenaed records from prior employers. When you're dealing with maybe a psychiatric claim and the good faith personnel action, you might want to get a personnel file, which would also be evidence that you would use, and there are discovery techniques that you use to obtain that information and what you pull out of it to use for the defense of those kind of psychiatric claims. Another type of piece of discovery is medical legal evaluations, and that involves panel qualified medical evaluators as well as agreed medical evaluators. And those are doctors that they don't treat, though. Their role is really different in the workers' compensation system. Their role is to just evaluate. And so they will examine an injured worker, or in the matter of a death case, they will review records and maybe talk with, the widow or any dependents. But those doctors' roles is to evaluate. And so what they do is they will see the injured worker, they will review all the evidence. Again, we gather that evidence through discovery, and then we give it to those doctors so they can evaluate the case and determine, again, what compensation is due the injured worker. Well, discovery is a little different in workers' compensation than it is in civil. We don't do interrogatories like civil does. I know people in the civil world, and they have, hours and hours of answering interrogatories, and that is a bunch of paper, and it really clogs up the system. Workers' comp doesn't do that, right? Because workers' comp, the whole point of the system is that injured workers don't need attorneys, right? That's kind of the basis of it. Is the state of California, when they created this, they wanted an ability for an injured worker to be able to handle this on their own. So our discovery rules are a lot lax. There's not as many timelines or specificities as involved in workers' compensation as compared to like civil discovery rules. All issues regarding discovery are going to bring to the Workers' Compensation Appeals Board. And then that's really the important thing to talk about, too, when we talk about discovery, is whether there is an ADJ number. And that's basically a case number. So when an application for adjudication of claim is filed with the Workers' Compensation Appeals Board, that gives it a claim number, which is what we call an ADJ number. And so that number is what gives the jurisdiction to the Workers' Compensation Appeals Board in order for them to hear disputes. A lot of injured workers, they have cut their finger, they file what we call DWC-1, which is a claim form, give it to their employer. Couple, visits to the doctor, they're done, back to work, everyone moves on, they're on their way. Those kind of situations, discovery is really only them going to the doctor, but there's no permanent disability and there's no need to have an award or go to the Workers' Compensation Appeals Board. When doing discovery, when you have an ADJ number, that's what gives the parties the ability to subpoena records. That gives the jurisdiction to the Workers' Compensation Appeals Board so you can go to them and resolve disputes. Mainly, it's the defendant who's in charge of discovery. They're the ones who pay for it. They pay for all obtaining of subpoenaed records. They pay for all the treatment, all the exams for the most part. There's a small amount of exceptions. But it's really the defendant, and that's kind of the driving force in a lot of cases. Now, with that said, there is still the burden of proof. And the burden of proof is on the injured worker in most situations to prove their case. They have to prove they were injured. They have to prove how injured they are. But there are some times when the burden shifts to the defendant. But with regard to who's really the driving force behind the discovery, 9 times out of 10, it's usually the defendant, because they want to make sure that they limit their liability. I mean, our role as workers' compensation attorneys is to just ensure that injured workers get exactly what they are entitled to and not a penny more. If they're 100% injured, they're 100% injured. If they're not injured, then they're not injured. And it's our job to figure that out. And so there are times when applicants' attorneys, or even a pro per injured worker, meaning they represent themselves, they may request like a panel qualified medical evaluation. They may want a second opinion to see what's going on with them. But as far as normally obtaining records, trying to get what we call apportionment, so maybe there's some other factors involved in their permanent disability, and so we want to make sure we get those records and get them to doctors so they can evaluate that and determine what role maybe some of these other pre-existing conditions are having on their workers' comp injury. So at the end of the day, I find in my experience, it has been defendants that are mostly the ones who push the discovery. But again, there are times when the applicant does as well. Who pays for discovery and workers' compensation is the defendant. The defendant is in charge because, again, this is a system that involves the injured worker being able to get the benefits they're entitled to and not always needing an attorney. And it's also, workers' compensation benefits are capped, right? So we don't do pain and suffering. It's not like a civil lawsuit where you can get the moon and back. And so because there are limits on how much an injured worker can receive, then they put the legislature decided to put the onus on the defendant to pay for all that discovery. I think the legislature also wanted to make sure that attorneys would take cases for injured workers. So if attorneys had to shell out thousands and thousands of dollars and not get that much in return, then they didn't think that attorneys would take those cases. So what they did was they made it that it's the defendant that is in charge of paying for discovery. And I really think that makes sense at the end of the day. When dealing with the defendant, that's going to be the employer who's self-insured or the insurance company. There are tactical advantages to both sides when conducting discovery, but nobody can be an obstructionist, right? I mean, the injured worker has a duty to relay and provide the information from their private doctors and other places they've treated and other injuries they have. So they can't sit there and just say, I'm not giving you information, defendant, too bad, you figure it out on your own. No, each side has a responsibility when it comes to discovery. But there are tactical advantages when an injured worker may not want certain information to come out. And they may have some private things involved in their life that really don't involve, the injury. And so there might be some ways that their attorney is going to use discovery to that tactical advantage to maybe not get that information out. With regard to defendants, sometimes we have to be a little creative in how we get some of the information, because injured workers may be not as forthcoming or may not really remember things. And so we have to use other things like maybe an ISO claim search, which is a search that we do that searches the injured worker's name, social security number, address, of the whole claims database all over the United States. So you find out if they've ever had a, motor vehicle accident, if they've ever had like a home insurance claim, anything like that. So there are some other ways that we have to maybe use discovery to our tactical advantage in order to gather information outside of maybe just a deposition or subpoenaing records. I think depositions are a very important aspect of discovery. I think that the ability to sit there and talk to the injured worker one-on-one and get their story and find out what's really going on with them, I think that really helps defendants. I think you can find out what are they able to do, what are they not able to do, what do they think really is going on with them. And then you can use that information to go get SBROSA. So that's another fantastic tactical tool when it comes to defending workers' compensation claims. And SBROSA is when you send out investigators and obtain surveillance of injured workers. And what we do is many, many companies out there that different insurance companies or third-party administrators contract with, and they will go and hire these companies that will then send people out to sit in front of their homes and get video of them going to the store, walking around. I mean, sometimes you can get video of people, like working on their cars or, re-roofing a home. And that type of tactical advantage a defendant can have when it comes to how hurt is this person. And that's what we find is a lot of times people are hurt, but how hurt are they? And that's really the question. But with regard to depositions, there's not only the injured worker's deposition, which gives you the ability to talk to them, find out where they treated, and gives you the chance to obtain information and go subpoena records from their private doctor. You also can depose doctors, right? So that's a really tactical advantage that the defense and applicants' attorneys can use because that gives them the chance to show doctors, hey, maybe you missed this, doctor, right? Maybe you didn't catch this. So you can go meet with them one-on-one. You bring evidence with you. Either sometimes you bring a job description, right? That's another fantastic tool that both sides can use to help their case. And you bring all that to the doctor. You can depose a treating doctor. You can depose a panel qualified medical evaluator. You can depose an agreed medical evaluator. Using depositions not only with the injured worker, but with doctors as well, I think is a very important tool for both sides. There's also times where you depose possible witnesses. I mean, let's say you have, let's say you have a case where an injured worker didn't report the injury for a really long time. Well, you want to find out from the supervisor, did they mention anything? Other coworkers, and find out what's going on. And so you can depose them as well. So yes, deposition is a really great tool, I think, for both sides. With the injured worker, I think more for the defendant, it tends to be more helpful. But I know there are some applicants' attorneys out there that love it when their clients are deposed, because that gives them the chance to really share their story and share what's really going on with them. One aspect of discovery is medical legal evaluations, and that involves a panel qualified medical evaluator or an agreed medical evaluator. And what those doctors are, their role is to evaluate the injured worker, and it's to find out what is going on with them with regard to their level of permanent disability, temporary disability, apportionment. There are also times those doctors may say the injured worker isn't maximally medically improved or at permanent stationary status, and they may make some treatment recommendations or want some additional testing done. And those doctors' roles are very vital. They're not required on every case. You can settle a case with a treating physician's report. You can also settle denied cases without going to a medical legal doctor. But I do find about 90% of cases do get a medical legal doctor involved. And a panel qualified medical evaluator is a doctor that registers with the Department of Industrial Relations with the state of California. And those doctors have to take a test, and they have to be certified by the state in order to be a panel qualified medical evaluator. And how they get involved in a case is a party has to request a list from the state, and 3 doctors get put on the list. And out of those 3 doctors, there's a striking process that goes on, and then the remaining doctor ends up being the panel qualified medical evaluator. And that's for represented cases. Now, if you have a pro per, an injured worker without an attorney, you cannot agree to an agreed medical evaluator. Your only choice for medical legal discovery is a panel qualified medical evaluator. And in those situations, the rules are different. There's not a striking process. The injured worker is able to select that doctor after a 10-day time frame. So that is, I think, an avenue that a lot of injured workers like to use because they really want that second opinion. A lot of information and assistance officers, those are the people that are at the Workers' Compensation Appeals Board that provide free help, if you will. It's a person with the state who's just there to help injured workers. They're not biased, they are just independent assistants. And so a lot of times when they talk with those people, they always talk about a free second opinion. And that's basically the panel qualified medical evaluator process. The other medical legal evaluator can be an agreed medical evaluator. And those are doctors, but you can only use an agreed medical evaluator if the injured worker has an attorney. If the injured worker does not have an attorney, that's not an avenue you can go. But you're not locked in necessarily. You're locked in definitely more with agreed medical evaluator on what that doctor's opinion is. There's a lot of case law out there that kind of says once that doctor says certain things, you're kind of stuck with it. But you can still use the deposition process to depose that doctor and use the evidence that you have gained through discovery to present to that doctor to see if you can change his mind. And one of the things we use a lot is the AMA guides. So in workers' compensation in California, the level of permanent disability is determined by using the 5th edition of the AMA guides, or the American Medical Association guides. And that's how the doctors determine the whole person impairment of an individual. And so we use that whole person impairment, we put it into a formula, and that's how we determine their permanent disability. So with that, you can present that to a doctor, because a lot of times a doctor forgets, they do the medical side, not the legal side. And so there are times you really have to remind doctors, hey, can't really go that route, guy. Remember on page such and such of the AMA guides, you need to stay within this box. And so you can present that to the doctor and then get them to change their mind. Now, with a panel qualified medical evaluator, the rules don't lock you in so much as what the doctor says. But you can depose that doctor too. So again, there's always avenues for both sides to use in order to try to get these medical legal doctors to change their mind.